Good afternoon. This is Vicki Partlow, and this is for EDL 850 Module 12 on tort liability. So what is tort liability? It is a legal term that kind of describes the violation of where one person causes damage or injury to or harm to another person. There are three main types of tort. The most common type of tort is negligence. These are actions which are not deliberate. However, they due to some kind of carelessness or not paying attention, they do cause harm to another person. Intentional tort is when a person purposely engages in conduct that causes injury or damage to another. And then the third type is called strict liability. And this is liability that applies without proof. And what matters is that an action occurred and resulted in an injury to another person. And I think some of the most common ones of these are like factory default, defective items, such as, let's say your stove blew up by accident, and you got burned or things of that nature. There's no person, that has done a deliberate action against anybody, but there was something that happened and injury was the result. So I reviewed 5 different cases, and the first case takes us to the state of Georgia, and this is Barnett versus Caldwell. So in this case, the high school teacher left the classroom to go to the bathroom. And during this time, Anton Williams and another student were horseplaying, carrying on in the classroom. This resulted in Anton falling and dislocating his collarbone. However, it dislocated in such a way that it caused a laceration to a major blood vessel. And as a result, Anton died. So Anton's parents sued the teacher for wrongful death based on negligent supervision. In other words, the teacher wasn't in the room supervising. Therefore, since she wasn't there, this is what happened. If she had been there, this could have been prevented. The trial court actually found in favor of the teacher, as her absence was considered a discretionary act that entitled her to official immunity from the duty to supervise students in the classroom. So discretionary acts are acts that kind of involve personal judgment and deliberation. Like, this was not something that she purposely set out to do to hurt him. This case was appealed to the Georgia Court of Appeals on the sole issue of whether or not this teacher was entitled to official immunity. However, the Court of Appeals did uphold the lower court's ruling, as did the Georgia Supreme Court. Basically, she made a poor decision. She decided to leave the classroom. There are some issues with this. Like, she initially, when she reported it to the principal, she said she had not left the room. She also indicated that she had called another teacher to kind of watch her room, or not called, but asked another teacher to watch her room. So there were some little issues here and there, not necessarily a truth told at first. However, it basically was that she just made a really bad decision to leave the room. Understandably, as a teacher myself, we always have to go to the bathroom. And, you would think that leaving high school students alone would be particularly okay. Reactively, in this case, again, the teacher tried to cover her tracks by indicating that she had not left the room when questioned by the principal. It's hard to predict what reactive behaviors would actually occur in our own schools. I do know our administrators are there to help us, and so by being honest up front is key. This teacher also indicated that she asked another teacher to keep an eye on her students. However, she probably could have prevented this by calling the front office and having someone come down to cover her classroom. Proactively, again, protocols need to be in place that establish guidelines for when teachers leave the classroom, especially at the high school level. As teachers, we place more faith on teenagers on being able to be left on their own for a few minutes. You don't think about it, but I mean, these are, juniors and seniors, and you would think that they could be left alone for, the 5 minutes you need to run to the bathroom. Um, However, in this instance, that was not the case. Professional ethics, under the Virginia standards for professional practice, um, we are charged with maintaining that safe student-centered environment. The key here again is, maintaining a safe environment for all students. Those protocols need to be in place when a teacher needs to leave the room. As a preschool teacher, I myself, always have to run to the bathroom, but I have, two other paraprofessionals in my classroom. So for me leaving the room, I am not leaving my 4 and 5-year-olds without supervision. I do remember in elementary school, though, being in 3rd and 4th and 5th grade, and teachers leaving the room all the time and putting a student in charge. And I would never in a million years do that now with our 4th and 5th graders. The case number 2 comes out of the state of Texas. It's Pierce versus Hearn Independent School District. The interesting thing about Texas is that teachers are considered government employees. In this case, a young boy, 16, Dijon Pierce, he lost control of an ATV he was driving. This ATV actually belonged to his teacher, who, as part of the students' coursework, Dijon was working on the teacher's farm during the school day. So essentially, the principal had given the teacher permission throughout the year to have students come with him during the school day. So he would check them out, and they would come and work on his farm. And there was no parental permission for this. They just, as part of the agricultural class, they left with the teacher. He drove them to their farm, and, they did farm work for him. The district court dismissed the claims for lack of subject matter jurisdiction based on the basis of sovereign immunity. Sovereign immunity essentially is that government employees are immune from lawsuits, particularly those in tort. So so unless those claims relate to property damage, personal injury, or death as a result of operation or use of a motor-driven vehicle, the Supreme Court of Texas actually interprets this statute as operation or use of the vehicle by a school employee. So because Dijon was not a school employee, he was a student driving an ATV. Therefore, the teacher was not liable for any kind of damages because that resulted in Dijon's death. So the Supreme Court of Texas also upheld that district court's decision, and no action was taken against Hearn Independent School District or the teacher or the principal. Reactive measures in this case would have been not to allow the students the use of motorized vehicles or farm equipment during a school-based activity. I actually been on a farm quite a bit with friends of mine when I was younger. That farm equipment is not equipment that I would let high schoolers use as part of a class because, if they've not grown up around it, if they don't know, or have not used any of it, it's pretty dangerous things to be around. Furthermore, I don't think I think the court findings were also saying that this child did not have a license as of yet. But needless to say, he sent Dijon over to another farm, and on the way back, him and another student, he lost control of the ATV, and they were both ejected, but he ended up passing away. You just don't. I think reactively it would, not to have students use motorized equipment, especially since they didn't have parental permission, that the principal was just letting them, be checked out by the teacher. Our school district is very big on getting parental permission in writing. For kids to leave the school grounds with a teacher. We're As teachers, we're not allowed to transport children other than our own without written permission from a parent. So even if two teachers at school know each other and they're going to take somebody's, child home for them, they need written permission. Um, So this was also considered a vocational class. So these policies and procedures would need to be in place that outlines the requirements for the class, and parental permission would need to be obtained. Furthermore, there should have been more than one teacher present. So if you're going to be doing work on a farm as part of vocational training, you need to have more than just one adult present for this, and also the use of a school bus, not driving children in your personal vehicle to the farm. Um, Again, we talk about our professional standards in terms of the learning environment, that includes those teachers of career and technical education. The key here is to maintain a safe environment for all students. So this specifically mentions in relation to work-based learning sites, being a safe and positive environment. Your classroom is the agricultural setting, the farm, that is your classroom. You need to maintain regulations on that farm so that children be in safe environments. My third case is from the state of Nebraska, Hatkick versus Millard School District. This is actually an older case. This case took place in 1974. This was a freshman, David Branhakic. I'm not pronouncing that correctly. He was hit in the head with a golf club during a physical education class. He lost consciousness and he died 2 days later. Interesting facts about this class is that, about this case is that David actually had been absent from the very first day of class. And so on the day he was there, the teacher was absent and was being led by a student teacher. This also was a time when girls were taught from a female teacher, and boys were taught from a male teacher. The female teacher had all of the girls to the other side of the gym. The student teacher was teaching the boys. He was off with somebody else helping them. David had asked a friend of his to help him, I think, show him how to hold the golf club and how to swing the golf club. And he wasn't standing far enough back. And when the other student swung, it hit him in the head. In this one, the initial trial at the district level sided with the plaintiff and awarded over $53,000 to his estate. And the school district appealed. The Supreme Court, there were, out of the 7 judges, 2 of them were dissenting, but the rest upheld that trial court's verdict against the school. And so David's estate was awarded the $53,000 for this accident. Reactively, this particular lesson could have been postponed until the teacher returned. Those rules and requirements needed to probably be reiterated to the entire class every single day, because as we know, high school students, you have to tell them something over and over again, same as you would preschool children. Also, if students that were not there, that's all new information to them, and so they really need to know it before anything started. Proactively, this is an older case which is set in the 70s, and the requirements for physical education probably or have changed. However, on days that students could not go outside and practice, the teachers would be responsible for maybe discussing the game in detail and not engaging students in playing the game indoors. Granted, they were using wiffle balls, but they were using actual golf clubs, so they have the potential of hurting another student by accident. Also, we always have alternative lesson plans in place for days when teachers are absent. And so maybe that would have been a little bit better for that student teacher to rely on. So one of the things that we have to remember professionally is that um, not only are we providing safe and learning experiences, we also need to manage our space, our resources, and our equipment, as physical education teachers, so that students do, remain safe in that environment. Swinging a golf club inside is great and everything, but there should have been some protocols in place where, everybody needs to be standing so far back. When we go to, those golf places where you can practice a swing, there's, boundaries set up and, webs set up. So things of that nature probably would be an important key to keeping that safe environment. But again, this was in the 70s. I don't know that they would do that in, nowadays play golf inside. The fourth case, I think, is a pretty popular case. Came out of the state of Connecticut, Munn versus Hotchkiss School. Out of all five of my cases, I think Hotchkiss School is the only private school mentioned. So this was a 15-year-old girl named Carla Munn, and she went on a trip to China with her. It was a school trip, and she was bitten by a tick, and she contracted encephalitis. And this left her with some severe neurological damage, and she's unable to speak, as of the writings of this case. She did not want to ride down with her friends, so a few kids decided to hike through the forest down to the meetup spot, and she got bit by a tick. The parents sued the school district because they failed to warn parents that this trip might put students in contact with disease-bearing insects. The parents and Carla was awarded over $40 million. The school appealed to the Connecticut Supreme Court, and that Supreme Court upheld that $40 million verdict. Reactively, organizers of the trip should require all students to wear appropriate clothing, shoes, and use protective sprays to decrease the opportunity for sickness. These items should have been included on the students' packing list. I have a little problem with this court case simply on the fact that sometimes we failed to use our common sense about things. It would make sense to me that if you were taking your children, or if you're sending your child on a trip to China, that, certain things might be needed for that. Catching encephalitis from a tick will, getting ticks in China are no different than getting ticks here in Kentucky or Virginia, those kinds of things. So, I don't know. I felt 40 million was a bit much, but, proactively, our school districts really, I don't believe, offer overseas trips. I've not ever seen any of the high schools take any. There are students, and students are involved in quite a number of activities that take them through the state of Virginia, and occasionally out-of-state experiences, including DC. And these trips are typically over-chaperoned with a number of teachers and staff available, and parental permission is always obtained, which I'm sure, all that was taken into consideration when they planned this trip to China. So we just have to remember that the learning environment extends past our classroom. So if we're taking children on a class trip, then that class trip, that trip is probably considered our classroom. And so we have to really remain diligent in our responsibilities to our students. The last case is the case in Kentucky. And the reason I was drawn to it is because one of the defendants, Fentrez, is Ronald Sonny Fentrez, and he was our superintendent in Anderson County Schools for 20 years. In fact, went to school with all his children. And he has since been what they call I call him a traveling interim superintendent. He goes around and he only spends a little bit of time over the last number of years as a superintendent until they find a permanent superintendent. So this is coming out of Floyd County, Kentucky. It's also kind of a big issue that we see a lot now. Stephen Patton was an eighth grader who was at the middle school. He committed suicide as a result of being bullied. His parents filed suit against teachers and administrators, alleging that they failed to implement sound policies and failed to know that he was being bullied under their watch. The circuit court granted in favor of the school district. The Court of Appeals upheld that summary judgment. And although the Supreme Court ruled with the lower courts, it did, however, say that teachers were not immune from suit on the basis of official immunity. However, the administrators were. So I thought that was a very interesting case. This is a very important case because we are seeing a lot more students, being bullied and being at school and then committing suicide because of this. Reactively, as always, we need to address those behaviors of students. It is no longer boys will be boys kind of world out there. Bullying behavior has direct consequences. And we need to help students understand that, even words cause such great harm to others. Anti-bullying lessons from counselors and trained personnel need to be initiated, as well as a curriculum throughout the school for social emotional well-being. We, are not immune in Stafford County schools from bullying. We have a lot of anti-bullying things that go on, especially at the elementary school level. But I really think, more needs to be done at maybe higher levels, middle school and high school. We do actually have great outside therapists that work in the schools. We call them TPT counselors, and they are actually therapists that come in and work with our students, especially our students who are Medicaid payers. They work a lot with students to help kind of mitigate some of those things that are going on in schools. We also have school site, basically roughly around two schools for every school psychologist. And they do, if we hear children who are saying things that are, about self-harm or harming others, we do have questionnaires that we fill out that the counselors or the psychologists fill out with the students to mitigate, to see whether or not they're having, a lot of issues and what we can do about that. Again, mental health is a very important issue that needs to be addressed, especially those bullying behaviors. Those, again, learning environment extends past our classrooms, and we really should be diligent in the responsibilities to our students. Thank you.